Is my child going to have to testify in a custody case? Hey there, my name is Ron Payne. I'm the CEO and managing attorney of Payne Law here in Kernersville. And as a family lawyer and as a child who went through a divorce, one of the questions that we frequently answer from parents is my child going to have to testify? There are two answers to that question, and usually the answer is going to be not really. An attorney can subpoena a child to testify. However, in my experience, particularly in Forsyth County, the judges do not want to hear from children. Now, there are times and there are cases that children can and should testify, but I'm here to tell you those times are rare. If you force a kid to testify, particularly if they don't want to, against their will, oh man, the judges are not going to have it. They are not going to be happy with you. Flip side is, if a child is too eager to testify, it's almost certainly going to look staged. It's almost certainly going to look like it was driven by the parent. Because what parent wouldn't want to prepare their child to testify before the judge? If you're going to put a kid through that, you're going to want to make sure that they are prepared and that they kind of know what they're going to say. But if you rehearse it, or if it sounds like phrases a parent's going to use, it's going to backfire spectacularly. And for those reasons, it is extremely rare that a child testifies in court. Now, the other part of that is age. If you've got a child who's 14, 15, 16, 17, maybe they witnessed something, or maybe they have a really strong preference and a reason that they can articulate. Not a reason that their parent has told them, man, your dad is on drugs, or man, your mom is always a drinking. Not something like that, but where they have seen things. Or maybe, the other parent is unable to be there. Maybe the other parent is unable to be there. Then they could testify. They can choose to testify, and you can ask that the attorney call them to testify. It's just atypical. The judges don't want to hear from children. As a child who did testify when I was young, that is not an experience that you want to go through. I testified, the courtroom was empty. I remember basically just speaking to the judge. And typically for younger children, they're just going to talk to the judge in their office with the attorneys present. So it'll be a lot more informal. But it's really stressful to put a kid on the stand. And so if you're thinking, I want to have my kid testify, you probably shouldn't. It's probably not going to help as much as you think. The judges aren't going to give it a lot of weight because they're going to presume they're a mouthpiece for the parent whose testimony is more favorable for. In those cases, you want to use a guardian ad litem. So is your child going to have to testify? Probably not. Should they testify? Probably not. Can they be forced by the other attorney or by your attorney to testify if they want to? Yes, and it'll probably backfire. I hope this has been helpful. If you find yourself in the unfortunate circumstance of a messy custody case where you might have to have a child testify, reach out to the team here at Payne Law. We've handled these custody cases. I have lived through these cases. We have the experience necessary to help you walk through those landmines and make sure that your family is best represented in court. Give us a call at 336-281-6928 or reach out to us on the web at applepaynelaw.com. Reach out to us on the web at applepaynelaw.com and we can help. We are Payne Law. We help families navigate life's important decisions. I hope this has been helpful, and until next time, have a great day.